Hello, everybody. I'm Bob Carr with Link SV, and I'm here today with Roger Royce from his law firm, um, and Don DeBruin from Link SV. And Roger has a lot of expertise, but he shares with once a month on a different topic of interest. We're all learning great stuff. And today we're going to talk about financings, all aspects of raising capital and the legal aspects. And believe me, as an angel investor, the last thing I'm thinking about is how I'm going to read all these documents and what I need to know. So actually, I'm going to learn something today, Roger. This is going to be good.
Okay, well, thanks very much, Bob. Thanks for that introduction. As Bob mentioned, today we're talking about the legal aspects of financings. And, you'll find hours and hours of content on my YouTube channel and my podcast about all the practical stuff you go through. We're going to focus a little bit more because this is a legal foundation series on the legal stuff. So I am going to hit the share button. Okay, hold on a second. Then I'm going to hit the presentation mode. All right, that should be working.
That looks like presentation mode.
Awesome. Okay, again, this is session number 5 in a series. You can find all the prior sessions on my YouTube channel. Just look for Roger Royce Law. And we're moving right along here today to what is probably should be the most popular topic. It seems to be the one that most people are interested in Silicon Valley, and that is financings. All right, here, let's see if I can get it to advance. I should have said this 5 times before, but better late than never. Although I think it's kind of obvious to everybody that, I'm a lawyer, but I'm not yet your lawyer. And this is not legal advice. This is just general information. So before you rely on any of this, talk to a lawyer because you change the facts, you change the answer. All right, our summary today in the little less than an hour that we've got left, we'll talk about angel rounds, priced rounds, how early money typically comes in, what venture capital deals look like, a term sheet, the essential elements, some due diligence issues. Of course, we always got to talk about tax. I can't help myself. And then if we have time at the end, we'll talk a little bit about some alternative securities offerings like royalty financings, token offerings, ICOs, etc. And hopefully I can touch on securities laws. But if I don't, I want you to know that next month's session is going to be completely 100% devoted to securities laws because that is something that we don't talk enough about these days and that needs to be covered. So I want to take you back in time to when I first came out to Silicon Valley and started doing deals many years ago. When early money came into a company, if there even was such a thing, because deals, priced rounds just tended to be before Internet Web 2.0, priced rounds just had to be bigger because you needed more money in order to launch. And, Internet 2.0 changed all that. So you don't need quite as much money. That's why you see so many startups these days. It takes a lot less money to get going. And the first money that came in as convertible debt. And the convertible debt was even, I think, something that was an offshoot of what we used to call bridge notes or bridge debt. But and the bridge part of that meant that you just needed enough money to get from the closing of one round to your next round. So we'd make a loan, and then that loan would convert into equity in the next round. It was intended to be short term. So convertible debt generally, typically short term, because the lender is not lending because they want to collect interest and clip coupons for the next 20 years. They're lending because they expect you to do a financing soon and they want stock in that financing. It's just that the company's too early for anybody to confidently value for purposes of a priced round. So instead, we'd say, you know what, we're going to loan you the money today. And when you do your financing within hopefully a year or so, my loan will convert into equity at that point. And I'll get in on the same terms that you negotiated with the VCs. So I know I'm going to get a good deal because the VCs are going to do their diligence and they're going to beat you up and make sure it's, a fair deal. Because it's debt, it had to carry interest. Okay, someone's transcribing. That's all right. Had to carry interest, and it also had to have a fixed repayment date. That is sort of the essential features of debt. And sometimes you'd see them, debt instruments that ignored those features. But typically that's how they were put together. By the way, if you do ignore those features, then you might not have debt. You might have something that for tax purposes is equity. And at a minimum, you've at least introduced some uncertainty. So you typically saw that. Once in a while, you'd see these loans secured, or the lender would say, well, if I'm going to be a lender, even short term, I think you ought to give me security. And even today in the venture debt space, you'll see loans secured sometimes. And because it's debt, the company has other bank debt out there. So if they're smart, they're going to say, by the way, we want you to agree to subordinate to our commercial lenders so we can at least, go out and get commercial debt when we need it. Now, there's a couple things about this, and I'm going to talk more about discounts and valuation caps later, but these concepts apply to debt as well as to these safes that we're going to talk about in a minute. But generally, one of the issues that came up with convertible debt, because every once in a while a founder would think about this, and they'd come to me and they'd say, I've been thinking this through, and if I default on this debt, so from the founder side, if I default on this debt, that means that I can be sued. And if it's secured, that means they can basically foreclose on all the IP I put up for security. But either way, eventually I get sued, the sheriff comes out, they levy, they take the company. And that is technically correct. That could definitely happen. That is one of the features of debt. And some founders will get a little freaked out by that. On the investor side, they're sitting there thinking, I've made a loan, but I don't care. I don't want an interest return. I want an equity return. I'm not going to, if the company defaults on the debt, then something's really wrong at the company. And I'm not going to go sue them to get an empty, pointless judgment. It seems like we're putting in place a lot of paper that is really artificial. Interest, fixed repayment, all these debt terms. And that's where the safes came from, because we kind of cut to the chase. Now, before I get to that, I want to mention that even in convertible debt, there was this concept that, gee, I'm early. I'm an investor. I got in early. Like when my $100,000 note converts into stock, I should get a better deal than what the equity investors got because they put their money in later. Plus, I took all the risk. You've had my money longer. I took the risk. I saw the future, etc. I should get a discount. So I should get my shares at about 80% of what they pay or whatever the discount is. The market's super efficient. It used to be back when we had discounts in determining what the right discount rate was. And that concept worked its way into convertible debt. Not immediately. There was another way of dealing with that I'll get to in a minute. But eventually it did, and it stuck around for a very long time. The other concept that worked its way in is, because everybody went through this, is a valuation cap. And the idea is, look, I'm going to give you my $100,000 today. When you're worth very little, it's going to convert down the road when the VCs come in. When you're worth a lot, you're going to use my $100,000 to get to that worth a lot point. You're using my money to work against me because the valuation's going up. I'd rather you kind of give me my stock at today's valuation, not the valuation 2 years from now, and, we've seen runaway valuations. I mean, we've all been through that where we kind of expected the money to convert within a year at something pretty close to what it's worth today. And it turns out that it converts a little further out than that. And the company just knocks it out of the park. And instead of a 10 million valuation, it's 100 million valuation. So that's the concept of a cap. We say, look, investor, we're going to protect you from a runaway valuation. You're going to convert at no greater valuation than X. Okay, so those are the concepts. And like I say, they do work their way into the safes. Before we get to that, I want to talk about something that we still see once in a while, but not nearly as much, is debt with warrants. And the way we used to do this is the angel, or even a VC, by the way, or whoever it was. The investor, of course, they'd buy this debt that converts, but instead of a discount and before discounts, in fact, there was a time when people come and they say, the investor wants a discount. What should I do? And I'd say, no, don't do that. Don't do that. Everyone's going to ask for a discount if you do that. Instead, give them warrants. But then the market shifted where everybody did ask for discounts anyway. But for a little while, it would be debt that converted, not at a discount in the stock, but on top of that, there'd be what we call warrant coverage. And that means that the investor was given a right. A warrant is a right to buy stock. Was given a right to buy preferred stock, and they could use their note to buy the stock. So warrant coverage would be the percent warrant coverage means what percent of the of additional stock can you buy as you convert your note. So the other, and that was elegant, but it was complicated. And there's a lot of issues to think through. Number one, what's the warrant price? And a penny warrant is what you would often see, and that's like free stock in effect. So for example, you could have a note that converts to stock, but on top of that, you got 100% warrant coverage, so you can buy, that much again. You get that much stock again, at a penny a share. That was something that we saw with troubled companies early on. Then it moved into just a negotiated concept, but usually it would be you could buy stock at the preferred stock price. So it's just a right to continue to buy. And you can think of it as sort of an anti-dilution feature because nobody would ever actually exercise. What you would do instead is what we call net exercise. And that basically means that a shorthand way of thinking about it is you take the spread, the difference between the amount of stock, the shares that you have a warrant with respect to, and your warrant exercise price. And that spread is what you get in preferred stock. Another way of thinking about it is that you're buying the stock with the shares, if that makes sense. So net exercise, you're just basically just exercising for the net amount. Like I say, it was complicated. When you had debt and warrants attached, that was an investment unit. We had to allocate the purchase price between the debt and the warrants. That means the debt was issued at a discount. That means it had what we call original issue discount, which gets amortized over time, and it creates interest income for the investor and interest deductions that the startup doesn't need for the startup. And it was really more brain damage than it was worth, usually. So along comes the SAFE, Simple Agreement for Future Equity. And it's basically a convertible note without a fixed repayment date and without an interest factor. So now it reflects the reality of what the investor really wants, right? What they really want is a right to have stock in the future, right? They don't want interest. They don't want to get repaid their money. They want to get stock. So that's what the Simple Agreement for Future Equity does. And I would say that it's not all that simple, and it's not equity, and it sure as heck isn't safe. That's what I tell people. And in fact, you will find those words right on the SEC website when they describe safes. So there are some things to think about, is how I would characterize that as we go through it. What you'll find in it, and by the way, the market again has become super efficient on this, and we're seeing almost the exact same form of safe being circulated. Very little gets negotiated in these anymore, and that's unlike convertible notes way back when those were negotiated transactions. On the conversion feature, there'll be an automatic trigger, right? When there's a financing, the investor has nothing to say about it, but after a certain amount of time, they might have an optional right to convert into common stock if they want to. The valuation cap we talked about, the discount we talked about. What happens if there's a sale of a company before we do a financing? And that can be handled one of two ways. One, either the investors, they get some multiple of their money back. I almost never see that anymore. Now it's that the investors automatically convert to common in the event of a sale at the valuation cap. So like I say, the market is becoming very, very standardized. Now, this concept of shadow preferred is worth talking about and pausing on, because let's imagine that investor has a safe, and it's $100,000 safe, but they've got a discount. And by the way, I'm not seeing that many discounts anymore, but let's assume there's a discount. And they get their 100,000, for 80,000, let's just say for $80,000, keep the math simple. For $80,000, they get $100,000 worth of stock. Well, they get preferred stock, and that preferred stock is going to have a liquidation preference, which we're going to talk about at length here before we're done. But they've only paid 80,000 for it, right? Let's say they paid $8 a share instead of $10 a share. But their liquidation preference should be $10 a share. It should be what they paid. The liquidation preference is what the preferred gets before the common gets anything, unless they convert to common. So in order to avoid that windfall, we have a shadow preferred, where the investor, the safe investor, on liquidation, they get back the actual money they contributed or some multiple of it, rather than the preferred stock price and the financing, to avoid that windfall. And that trickles through a lot of other things, the dividend rate, the conversion ratio, etc. So that's why you'll see shadow preferred for almost every class of safe that gets issued. And it makes closing super complicated these days, because it seems like every company, they've got 8 different classes of safes at different valuation caps. Some are pre-money, some are post-money, some have a discount, some don't, because these are all individually negotiated. That's one of the beautiful things about safes. You don't have a close where when you sell a safe, you don't have to have a closing where 100 safes get issued at one time. You can just continue. You can be in constant fundraising mode, just selling safe after safe after safe. Well, that means you are creating potentially that many different classes of shadow preferred if those safes differ. And you'd be surprised how complicated the math can get. And I never wanted to do math when I went to law school. Never thought I'd have to, but I seem to have to do a lot of it these days. Pre and post money, I'm going to talk about in a minute. MFN means most favored nation. That's the concept, which we now see in most of these, if not all of them. Because remember, the investor at this point, we're doing this to keep it simple. We're not going to do a lot of due diligence. We're not going to try to value your company. So we're not going to look under the hood as much as we thought we should. And we might not know something that the next investor, who's a little smarter than me, might know. And if they figure it out and you make a better deal with them than you made with the first investor gets the benefit at their election of that later deal. And tax treatment. Almost all safes now are treated as stock for tax purposes, because we want to start a holding period running. There's no IRS rulings on this. It may be a risky position, but what I can say is that's how it's typically done. I think it's a much stronger case for this with a post-money safe than a pre-money safe. But nevertheless, I think I see everybody taking that position at this point. By the way, you cannot take that position with a convertible note, because there is law on that. But you can take that position with a safe, which is another reason the safe really favors not only the company, but the investor these days. Now, the valuation cap. I want to talk a little bit about what we mean by this. So let's assume we have the company has a $4 million pre-money valuation, and we sell a $1 million safe. Okay, pretty simple math. That means the safe is going to take 20% of the post-money $5 million capitalization. Now, there's a difference when we have a pre-money and a post-money safe. And currently, about 80% of all safes are post-money. And that was not the case just a couple of years ago. It was probably 50-50 2 years ago. But now it's like 80% post-money. And the post-money means that the investor is getting X% of the company regardless of how many other safes you sell. So the investor knows what percent they're buying. The pre-money means it's as if you close the financing today and the investor is being diluted by all the other safes that get sold in the round. So think of it that the pre-money the safes take the dilution of other safes. The post-money is that the safes do not dilute for other safes. Let me show you what that means. Go back to my example. $4 million pre-money valuation, and the company sells $1 million safes. Well, if it's a $4 million pre-money safe, and we sell $2 million worth of safes, right? Two safes for $1 million. That $1 million safe is going to get 1/6, right? If it's a 5 million post-money safe, which say you come in with $1 million, it's 4 million pre, you're thinking that's 5 million post. So we're going to say this is 5 million post-money safe. Well, the company goes out and sells another $1 million post-money safe. Doesn't matter. It's 5 million post-money. That means my million gets 20% and the founder takes the dilution. So it's good to think about the math. And that's one of the traps in these. And this is what founders really need to do, is to go through and do what ifs and do pro formas and to get the spreadsheet out and kind of figure out where you are. Now, the commercial cap table tools out there will do this for you if you know how to use them, or you just do the math yourself, or you can just find a tool online. But you ought to have an idea where you are if everything were to convert tomorrow, because too many times I find some founders that go like for years selling safes and they really have no idea what percent of the company they have anymore. And they don't find out until they do a financing. And I've had it happen a few times where the price round investor, the VC, comes along and says, you've given away too much of your company. There's not enough left for the founders. You got to go back and recap. And that's a disaster. You don't want to have that happen. So kind of have a sense as to where you are. The other trap here is one, I keep beating the drum on this, is that it's like nobody pays attention to securities laws anymore. And it's, yeah, I know we're in a lax enforcement environment right now, both for tax, for securities, for FTC, for everything. But, I still believe in law and order, and I think we ought to follow the law. So it's so easy to go online and download a document, sign it, take the investor's money, and go on your way without doing all the necessary filings or making any required disclosures, etc. And that's not a problem until it's a problem. Let me put it that way. I'll talk more about that in a minute. Actually, I'm going to talk a lot more about that next month. Okay, so that's the angel stuff. That's the safes, the convertibles. Now I want to talk about venture capital, the holy grail, what every startup in America hopes to get some point. And as I said, I just now got here this morning and I opened up my email. And once here is the venture market report that Bob Carr has circulated and is in your chat. And it's great to watch these statistics and see where the VCs are putting their money, what stage they're investing in, how much their average investment is, what sectors, etc. I'm going to talk not about that. If you read the venture market report, if you want to know about that, I'm going to talk about the legal aspects. So when we talk about preferred stock, we talked in our second session about cap tables, right? And the first stock that gets issued generally doesn't have to be, but it's generally common stock. And think of common stock as the residuary, and that's what's left over after you pay preferences. The next class of stock that gets issued is preferred, and that class will typically be issued in series, because each series of preferred is going to differ a little bit, both in the issue price, the liquidation preference, maybe other features, the dividend rights, the other protective provisions, etc. So we divide them into series. And you might hear about pre-seed, series seed, and once you get past that, we get into the alphabet, series A. And within series A, generally based on what people have paid for that series A, you'll have series A1, series A2. And then when you hit the next valuation event, that'll be series B. And again, I've got hours on what the difference is between these two terms, but it's not legal. It's more just what the market calls them. And like, this is what you should be to call yourself series A, etc. So you can go watch that if you're interested. It has no legal effect, but it has practical effect. Let me put it that way, but not a legal effect. We could call it whatever you want. I want to talk a little bit about structuring for capital, because if we are going to go to the VCs, there are a handful of things that we want to do to get ready for the VC. And I often tell people that are about to do VC financings that, mistakes are free until you talk to a VC, right? We can fix anything you've done wrong up to that point. But if the VC tells you that you've done something wrong, it's going to cost you. It's going to cost you in valuation points. It's going to cost you maybe, who knows, escrows. I've seen that happen. It might cost you in just losing the whole deal. They might say, come back later when you've grown up. And in the meantime, we may just go invest in your competitor. So you want to be structured correctly when you get there. So we talked earlier at length about choice of law. The standard still is Delaware C and choice of entity, Delaware C corporations. That's what VCs invest in. Now there is a movement, as we've talked about, to go to other states. I am with a Texas law firm, and we're doing a lot of companies that have moved to Texas and incorporating under Texas law and taking advantage of what is frankly more favorable law in Texas. I'm licensed in Nevada, and sometimes we form companies in Nevada to take advantage of the flexibility in Nevada law. And roughly, I will tell you that the difference is Nevada allows you to be much more protective of management. Delaware requires you to be much more protective of shareholders. Thus, you might guess that between those two states, your professional investors are going to prefer Delaware, which affords them, statutory protections, rather than having to go in and try to figure out, how you're gonna beat them, through your choice of law. So even though I'm licensed in 6 states and I sit in California and practice in other states, 99% of the companies I form are under Delaware law because my clients tend to be looking for VC investment down the road. Cap table, we want to get that cleaned up immediately. It should be just as clean and transparent. You're going to have common stock, you might have an option pool, and you'll have convertibles. And convertible means convertible debt, safes, or warrants. We really don't want anything else on there. We don't want, you might have different classes of common stock, for example. Sometimes you have we've talked about this in prior sessions, super voting common or common that will convert into preferred on a financing. You might have stuff like that, and you might get away with it. I follow the KISS principle. I try to just keep it just as transparent and glass and clean as possible. But I'm seeing that come up about 1 in 10 companies will have some sort of, multi-class as a common. And if you're a good enough company, the investors they'll overlook it. They might make you change it in the financing, but they won't say, not going to even look at it. Vesting, whatever vesting you have in place, just plan on it being replaced when you do your financing. I'll talk about that in a minute. And then debt, if you have founder debt, don't be surprised when the investors ask you to make that debt go away. They want a clean balance sheet. So they will ask you quite probably to convert that debt into equity, contribute it to capital, something like it, make it go away, because debt gets paid before equity. So theoretically, the investor doesn't want their money going into the company, then right back out to pay debt if they can avoid it. Now, negotiation 101, whenever you do a deal, is get inside the other party's head. What is it that they want out of this deal? And there's the obvious stuff, right? There's a valuation. That's just win-lose. I don't care what the Harvard negotiation school says. That is zero sum. The higher the valuation, the better off the founder is. But a lot of this other stuff is not. QSBS, Qualified Small Business Stock. We've talked about this before. This is the idea that the investor can achieve a 0% rate federal rate of tax or rate of federal tax on their gains if they can get QSBS. And a company is for the most part indifferent about this. So help them do that. That's one that is not zero sum. Secondly, you should just know that most venture capitalists, their partnership agreements won't allow investment in a pass-through. That's why you're a C Corp. We've talked about this before. And then thirdly, understand that the VC, importantly, and this is not quite as obvious, but they really need to be able to manage their losses in a company. And I've got hours of video on how they do that, but for purposes of today, what that means is they don't want to pass through. They want a C Corp. So if they want to trigger a loss, they'll sell the stock in your company or something. And if they don't want to trigger it, they'll hang on to it. Typical cap well, I don't know if it's typical, but here's a simple example of a cap table. Now, when I go into a financing, when I sit down with the founders, and this drifts a little out of law and more into lore, I suppose. What I tell them is, let's work backwards. Let's figure out where you want to be when you exit and how much money it'll take you to get to that exit point and how many, and how much capital you're going to have to give up to get there. And let's just say that usually my founder says, well, I don't want to lose control in Series A because I know once I lose control, the company might fire me. So, but I don't mind losing control in Series B. So we'll have a little what if that starts out like this. Well, this is where I want to be at the end of Series B. And then we can, oops, I usually have more slides. Then we can back into it and say, oh, well, okay, that means you have 5 million shares. We'll go up to 3 million Series A with a 2 million stock pool. And these are not hard and fast numbers. This is just an example because the question is, how do we decide how much to sell and how do we decide to price it? And the VC has their own calculus. Again, I've talked a lot about on my YouTube channel, but the founders calculus, how to go something like this. It's not so much about valuation. It's about ownership percentages down the road and not just the economic rights, but also the control rights that you want to hang on to right past Series A and into B. Now, that isn't true in all sectors. I mean, in life sciences, you will oftentimes give up because you do big rounds typically early on. You'll give up, you might give up control in your Series A. All right, enough market issues. Okay, let's go to the terms themselves. Pretty much every lawyer in the world now follows the National Venture Capital Association model legal documents. They're really industry standard documents. And it saves us all so much trouble just haggling back and forth over little things and looking for gotchas. So this is where we all start, and this is where I'm going to start. Term sheets. The first step in when you talk to the VC, of course, will be soliciting hopefully more than one term sheet, but all term sheets are going to have some common elements to it. And the very first thing you're going to look at is going to be valuation. That's significant, but not the most important thing. Again, go back to my prior videos to find out why not. And but valuation is part of the formula because, first of all, as a legal matter, the valuation might not be the thing that tells you, it might not equal value. Let me put it that way, because you also have to look at liquidation preferences. You have to look at participation rights. And again, get out the spreadsheet if you have term sheets that vary on those terms and do the what ifs, because a higher valuation might not give you the best result. You'll see what I mean in a second here. But in any event, as a legal matter, I just want to be able to express this properly in the documents. So here's a typical term from a term sheet, well, from the National Venture Capital Association form on valuation. And they give you a pre-money, fully diluted valuation. So you get the pre-money valuation, the investor's money equals the post-money valuation. That's the general formula. Ideally, if I get involved early on, I want to have as much detail as possible on a term sheet from the company side. So I will just attach a pro forma and say, just so there's no mistake, this is what we're talking about. This is where we're going to end up after you give us your money. Because once in a while, stuff will happen during the deal and you might have to negotiate. Like, was that option included in your option pool or is that outside the pool, etc. Now, this is something that you as a founder, I don't want to say it's a gotcha, but I want you to understand this point here about the option pool. Notice how it says, and this is just standard stuff. This is market, which pre-money valuation shall include an option pool representing X% of the post-money capitalization. What the investor is saying is that, look, when the smoke clears, you're going to have X% set aside for an option. But that X% is going to come out of you, the common stockholders' equity, not out of me, the investor's equity. I'm investing so I have X% post-money. Well, what does that mean? Let me give you a really good example. Say that you have 5 million shares outstanding, held by the common, and the investor comes along and they value you at, I don't know, $10 million. pre-money. So you're thinking, oh, that's $2 a share. So that investor is probably going to pay me $2 a share at that valuation for their stock. No, that's not what it means, because they're going to have you set aside an option pool. And when you finally get to the price per share, it's going to be something less than $2, because it's not $10 million divided by 5 million shares. It's $10 million divided by 5 million plus the option pool shares. So that's what I mean. And it's just something not to be surprised about, but just expect that's just how it's going to go. By the way, I remember a time when nobody had figured this out yet, and it'd pop up and it's like, oh, that's clever. Anyhow, participation. One of the defining features of preferred stock is that it participates. It can participate or not be non-participating. And participating means that it shares in the proceeds of a sale. Non-participating means it either gets a return of its investment or its pro rata share of proceeds. These days, almost all the deals I do are non-participating. Okay, we don't have participating preferred. And I mean, that's just the market. I mean, once in a while you do. If you get outside of Silicon Valley, you'll see that. If you go to other countries, you'll see it a lot more often. If you go to Asia, you'll see it a lot. Now, when you do have participation, in other words, meaning the preferred stock gets its investment back and then it gets a share of the proceeds, it's almost always capped at some multiple. So yes, you get your money back, plus you get your pro rata share until you get 5 times your money or 3 times your money, whatever it is. Usually the way this works is that non-participating preferred, it'll be the greater of the amount that you've invested. So when you sell the company, you, the investor, get the greater of the amount you've invested, or you get your pro rata percentage on a conversion to common. And that's how it's typically drafted. Dividends, the preferred will have a dividend preference, meaning that the preferred stock gets paid a dividend before any other dividends get paid. Now, the concept that you should keep in mind is the difference between a cumulative and non-cumulative dividend. And a cumulative dividend means that there's a rate, right? Say it's 8%. And if you get to the end of the year and you don't have earnings and profits and you can't pay that 8%, the cumulative dividend just carries over. So now you owe the investor the investment plus 8%. And a year later, you're going to owe them another 8%. And it carries over and carries over and carries over until you sell the company. Now, you don't see that in venture capital deals. We have non-cumulative dividends in VC deals, meaning that dividends are paid only when, as, and if declared, which is another way of saying never. Okay, how is never? Is never good for you? Because that's good for the company. But in private equity deals, you almost always see this because that's how they value the company and that's how they determine their return. And be careful, it's not just an insignificant thing in a term sheet, because an 8% that's high, but let's say you have an 8% cumulative dividend, that could really add up, by the end of the term. Just do the math, right? You'll see that a lot of private equity deals, they really rely on the cumulative dividend to make their numbers. Liquidation preference, we sort of talked about. It's hard for me to talk about participation and preference separately because they really work together. And it's just the idea that the preferred stock, they get their money back first before the common. Remember, the common's a residuary, gets anything. So do I have an example here? No, but I've got language. So here's how participation and liquidation would work. So in event of any liquidation, by that we mean a sale, effectively. So alternative one is typical non-participating preferred, which I see in every deal now. It means that the preferred first gets their purchase price plus any, accrued, declared, unpaid dividends, which is going to be 0 typically. Or if greater, the amount they would get if they convert it to common. So their percentage. So I put $1 million in for, 10 million posts. So I got 10% of the company for about $1 million. I think I've got an example here. Hey, what do you know? And we have a sale for 5 million. I have 1x non-participating convertible preferred, right? We have a sale for 5 million. Well, let's see, 10% of this is 500,000, but I put in 1 million. So you know what? I think I'm going to take my million. Yeah, I'll take the million. Instead, I'm not going to convert. I'll just take my liquidation preference. You sell it for 20 million. Well, let's see, 10% is 2 million. I put in 1 million. So my liquidation preference is 1 million. My percentage is 2 million. I'm going to convert. I'm going to take the $2 million. That's the concept. Let's see if I can get this. Oh, darn it. Let me move back. Okay, so that's non-participating preferred. The alternative, I'll just mention it because who knows, the market might change and this might come back into vogue, is that we give the Series A preferred its money back first, and then on top of that, we give it its pro rata percentage. So in this case, the preferred gets its $1 million plus 10%. Okay, so you can see why that's not very common anymore. Okay, let's move right along from economics to control, because those are usually the two major components of a term sheet and a venture financing. Board representation will be negotiated. The size of the board, there are these things called founder-friendly boards. The role of the board, whether the VC, if they don't get a board member, they get an observer. That's somebody that can sit in on the board meetings and just observe. The indemnification that they get. And by the way, you will always be asked to buy D&O insurance for your VC board members. I'd be quite shocked if they let you off the hook on that one. So just be prepared for that. Size of the board, typically after the first round, the first VC that comes in, I typically see 3 members. The founder gets, the common stockholders get 1 seat. The VC gets 1 seat, and the third one is some industry luminary that we all agree on, but not necessarily. But that's typically how I see it. Sometimes we'll go to 5. Board rights, we talked about indemnification, D&O insurance. I want to mention, because I'm only halfway through my slides and 3/4 of the way through the presentation, I want to mention the idea of a class vote. And one of the other reasons we always use Delaware, I said it's protective of shareholder rights. I need to set this up for you. Under some states like California, there is a statutory requirement that every class of shares gets a right to vote on certain decisions, like sale of the company. That means the common stock could block a sale. I'm going to give you an example of how this played out in the real world before we're done. But let's say we have a sale and the sale does not produce enough proceeds to clear the preferences. The common stock is always going to vote no on that, because why should we vote for something we're not going to get everything? The preferred's going to take everything. And believe you me, there are a lot of companies out there where the founders are just working for the preferred. They just don't know it yet because there's so many, the preference stack is so big. Well, Delaware law says, look, we can abrogate that and we can provide in our certificate that we're going to have a majority vote of all classes voting together control. And that way you might have a couple of unhappy founders that don't like the deal, but they can't stop it. It's one of the reasons we always go to Delaware. I want to mention that because that leads us into protective provisions. You'll always see the VCs ask for certain protective rights, certain rights that they have to basically veto or approve any decisions of the company. And I've listed sort of the standard provisions, and then I've listed some of the other, optional provisions that tend to get negotiated. And given our time, I'll let you review those at your leisure. But the one big one is sale of the company, right? The VCs really want to have a right to block or approve a sale. Well, the other big one is amending the certificate, company certificate, because if you're going to sell another series of preferred stock that's prior to and ahead of the existing investors, they want to have a say on that issue, right? Because that very much affects them. Information rights, that's something that tends to get a little bit negotiated because companies, they may or may not want to do GAAP. Investors are going to want to have generally accepted accounting principles. They're going to want to have audited financials, and that is expensive. The real negotiation is what's the threshold? Like, how many shares do you have to have before we have to go to the trouble of giving you all this information every quarter? Reg rights, I don't want to say a lot about because registration rights are almost never negotiated, because in the 40 years I've been practicing, I don't think I've ever seen anybody exercise a registration right. but they're almost in every deal. And that's the right that an investor has to force a company to go public, or if they are but in the United States, the way we do it, unlike other countries, is that shares are actually registered. And then the SEC allows the shares to be sold in the public market. We don't register companies, register shares. So if a company lists shares, the investor could say, look, I hereby demand that you register my shares so I can sell them. Or if you've already got shares being registered, I want to piggyback on that. Or if you're in a position to use this S3 abbreviated procedure, we can demand that you do that. Almost never done, just for market issues. You got to find a reputable broker and they're going to do what they want to do. Conversion. Sometimes your preferred stock will convert to common. And like an IPO is kind of the typical, you convert everything to common when you go public. But sometimes the majority of the holders might say, you know what, we got to get rid of the preference stack or this company's going nowhere. We won't attract any more capital. So we're just going to elect to convert everybody to common. That's not a happy event when that happens, by the way. It means something has gone wrong in the projections, but it does happen. Other restrictions, you'll hear about the ROFR. That's the right of first refusal. You, the founder, you cannot sell your shares without first offering it to the company. If the company doesn't want it, then offering it to the investors. And if they don't want it, then you can sell it to a third-party buyer. However, you have to give the investor the right to participate in that sale. That means they get to sell some of their shares to that buyer along with you. That's how it typically works. There's usually a carve-out. I look for 5%. Sometimes it's less. The carve-out means that the founder can sell some shares free of these rights because they might need a little bit of liquidity. And these transfer restrictions really do chill sales. The drag along is just the flip side of that. The investors found a buyer, not the founder. They want to sell, but the buyer wants all the shares, not just yours. So they'll force the investor to sell their shares along with the investor. The real effect of a drag out is to get around some appraisal rules and dissenters' rights, which is beyond the scope of what we're going to talk about today. Founder vesting, like I said, just expect to reset. I think we talked about this before. It used to be, everybody starts off with 4-year founder vesting. There was a time when that's all it took to go public or exit. These days, it takes much longer. So every financing, we kind of reset that clock. And that is typically negotiated. So just be aware. Acceleration we've talked about before, double triggers, single triggers we've talked about before, but just understand that you're going to be unvested for a long time, more than the 4 years that you think, unless you have a pretty quick exit. Pro rata rights, we also call the right to maintain. This is the right that the investor is going to have to participate in later sales of stock in our company. The negotiation here is not so much whether they have them, it's just who gets them. Like how many shares of stock do you have to buy before you have a right to keep buying shares as this company's value goes up and up and up and up. We talked about the option plan. Rarely see redemption rights, but it does exist. And this is the idea that the preferred stock, after a certain number of years, can say, look, you guys haven't given me a return yet. Therefore, I'm going to put my shares back to you. You have to buy them back to me, plus some reasonable return. And if the company, typically they don't have the money to buy back the investor. So really it's a way to force a sale of the company, because that's the only way you turn the investor into a creditor. And that's the only way to pay the investor back. Hardly ever see these days. Anti-dilution. What happens if you sell stock at one price and then you go out later and you sell it at a lower price? That's when these anti-dilution clauses kick in. Full ratchet means the investor gets the full benefit of the later price. In other words, their percentage interest does not change. Never see that. Only in troubled company scenarios. Weighted average is what we typically see. And it'll take us an hour to go through the math, but at a high level, broad-based weighted average gives a much smaller adjustment to the investor when they go out and do a late. Typically, these are all just waived, by the way, as a practical matter, because the investor has to approve the later financing. So as part of that approval, we'll just say, would you just waive your anti-dilution protection? And they will typically do that. Term sheets will have a no-shop, meaning once you sign that term sheet, you have to, in good faith, try to execute on definitive documents. And you have to be exclusive, and you're not going to go out and solicit any other offers. If you get another offer during this exclusivity period, you'll go tell the investor about it. So, they know, but anyway, you're bound for that period of time. Pay to play, just so you know what it is, it's the idea. Sometimes you see this, especially in bad economies, that the investor puts their money in, and now if there's a later financing, if the investor doesn't participate in the later financing because the company needs more money, their shares get converted to common, so they get squashed, right? And that's one way we do it. Is just that you no longer have your preferences. And usually they also get squashed in their percentage as well. So every 10 shares of preferred gets 1 share to common, something like that. It's a way to sort of force investors to stay in until the end. Keep in mind, term sheets are typically non-binding except for confidentiality obligations. Even though they're non-binding, everybody has a good, at least here in California, has a good faith obligation to negotiate and try to get to closing a deal. So it's sort of non-binding. It's kind of how I look at it, unless we put an absolute drop dead date on it. If we don't close by this date, it's all done. So that's what I always try to do, because if we can't get our deal done within a certain amount of time, it might mean that something's just wrong, and not all deals should happen. I want to mention, sometimes in these deals, you'll see troubled companies. They'll do down rounds. That's where you see all of these extraordinary things I was talking about. Forced conversion to common, right? Because the preference stack is too high. Nobody else will come in with that many preferences ahead of the common. The full ratchet anti-dilution that I talked about, you might see uncapped or even capped participating preferred. Maybe the insiders, the only people that'll put the money in. The down rounds we talked about, pay to play. These are all, I hate to say troubled company because that's harsh, but you will see these terms in a troubled company. Now I want to mention unsuccessful exits because that does happen. Sometimes, the investor, and I've had it happen over and over. The investor just says, I've had enough, we're done. Sometimes it's because their fund is coming to an end and they just got to liquidate. Trados shareholder litigation is super instructive, right? Because in that case, the board, which was controlled by the investors, they didn't have a disinterested board. And even the officers were under the thumb of the investors, according to the court. And you should just assume that every company, it cannot have a disinterested director transaction after this litigation, after this case. They sold the company for an amount that did not cover the preferences. That plus a management carve out did not cover the preferences. So the common stock was going to get nothing, and the preferred was going to take everything. So they had the board approval. They approved it. Common stockholders sued. And the court said, yeah, you're right. You should have gone through a better process because, you controlled the board. You didn't have a disinterested shareholder vote that you could have done. So you should have had a better process. But the common is right. And they recover zero because at the end of the day, you got everything this company was worth. So it's sort of what they call a Pyrrhic victory. But it's a good case to read just to understand how courts view these deals and fiduciary obligations. Venture debt, I wanted to mention some alternative things. It's exactly what it sounds like. It's just debt that's often raised after a VC round, and that's where you'll oftentimes see warrants. You may see security, but it's just very high risk debt with some equity. Royalty financing, we just don't see that here in Silicon Valley very often. You see that in other parts of the country, and you see that at angel level. That's where the investors, they want something a little more certain and a little faster. So the investor gives the company X dollars, they get back a percentage of income, a percentage of sales. So it's like a royalty. The regulatory and securities laws rules are complex, and it's hard to know what these people are. Are they debt holders? But we do see these in places where angels want to take a little less risk and get a little lower but more certain return. ICOs, I've done hours and hours talking about these. We just don't do these in the US anymore. I'm going to talk about, because of the regulatory environment, the securities law environment. Next month, we're going to spend an hour on securities law, and I'm going to dive into this a lot deeper. But this is the idea that instead of selling stock, we're going to create tokens and sell these tokens in order to raise money. And those are almost always a security. There are scenarios where they're not necessarily, but the SEC has taken a position that they are almost always a security and have to comply with securities laws, which raises a lot of issues we're going to talk about next month. Where you see it now in venture financings is there's oftentimes a covenant or a clause or an agreement that, look, company, if you go issue tokens, in a way you're diluting us. So you have to give some of those tokens to us, the investor, if you do a token offering. We'll talk about this mind-bogglingly complex ICO next month. Is it a security? And again, this is a good place to stop, because I was going to go through the securities law exemptions that we rely on when we do venture rounds. But like I say, we're going to do a full hour on this next month, so I'll leave it here. And if you want to get a preview, you'll be getting a copy of my slides, and you can review the summary. Look at all the slides I have on that. I'm Roger Royce. I'm a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital. And today has been my talk with Bob Carr on financings. So Bob, you want to take us out of here?
Thank you, Roger. I have some things I want to talk to you about that I learned today that are unusual. But yeah, I'm going to follow up with a conversation. Thanks for coming, everybody.